Hi folks, welcome to episode 6 of Critical Race Theory Explained. So far in this series, we have examined what the critical race theorists have been trying to do and how they sort of coalesced. So they began with Derek Bell objecting to the end of segregation. They moved on to discover that, or think that they've discovered, how the oppressed have got special knowledge. They have inserted Rousseauian assumptions on human nature in exchange for the Lockean ones that underpinned the United States, and how they're engaging, Kimberly Crenshaw specifically, is engaging in a Gramscian war of position against Western society with the purpose of overthrowing it and implementing communism, and how they achieved their racial consciousness. So next, we get to an essay that I think that non-Americans should pay most attention to, and one that seems slightly out of place of the critical race theory canon, because so far the critical race theorists have centered themselves very much within the Enlightenment tradition. They come from the left. They are neo-Marxists. So this is an evolution of Enlightenment thinking, and this essay is a kind of objection to that, to be honest. So we're talking about Essay 11, which is Translating Yonon Dio by Precedent and Evidence, the Mashpee Case, by Gerald Torres and Catherine Milun. So this essay revolves around a legal case involving the Mashpee Indian tribe and the insufficiency of the law in able to properly capture the concepts that they're using to describe themselves in comparison to the concepts that we use in the common law. And so it begins with the term Yonon Dio, which is at once a salutation and had become, quote, a medium through which Indian and European cultures interacted. So the problem is the inherent inability to adequately translate the meaning from the tribe into the English legal framework. They say, quote, the problem with conflicting systems of meaning is that there is a history and social practice reflected and contained within the language chosen. This essay examines the nature of that ignorance. So by imposing what Torres and Millen call ethno-legal boundaries onto the Mashpee tribe, law universalizes their story, and in this process eliminates differences the dominant culture perceives as destabilizing, as in the particular and parochial culture and definitions that the tribe uses to define itself as a tribe is destabilizing to the universalist nature of the Enlightenment project that is the United States of America. And so these legal boundaries, in their view, frees the Mashpee's cultural evolution and prevents them from changing and improving. And therefore what they're advocating for is a, quote, pluralistic conception of justice that would be required to actually establish something that we could consider just in this case. Now, we've done a premium podcast talking about this sort of thing before, called our Thick Concepts podcast, which we'll leave linked in the description, or you can just Google Thick Concepts and lotusseeds.com. And this is about how we actually, in the English-speaking world, it's not just in the Mashpee Indian case. In the English-speaking world, we have a great deal of language that is old language, and it's thick and deep language that contains packaged within it many different kinds of ideas and moral judgments, as well as evaluative descriptions. Things like murder or betrayal at once describe an action and a state of affairs and a moral judgment along with it. There's never a good murder, for example. There's never a good betrayal. It's always bad to have done these things. But that's something we discuss in that podcast, and I thoroughly recommend it because I think it's for many years, I wondered why I enjoyed reading ancient authors so much and why I found modern authors to be somewhat tepid by comparison. And it's only in my later years that I realized it's because ancient authors use these thick concepts as a matter of course, and they give weight and depth to the writing style. And it's what it brings out the beauty of the language. But anyway, returning to the essay, they go into the history of the problem with the Mashpee tribe. So between 1834 and 1870, the Mashpee claimed the Commonwealth of Massachusetts had permitted the lands of the Mashpee to be sold to non-Indians and had given Indian lands to something called Town of Mashpee. So it's a settlement that was from the colonial period called the Town of Mashpee. And the legal defense the town of Mashpee made against the Mashpee Indians was the Mashpee Indians were not actually a tribe. This means that the Mashpee had to prove they were a tribe, which meant a 40-day trial that required them to meet, quote, the narrow criteria defined by the Supreme Court in Montoya versus United States. And so this is the definition. They say, quote, by a tribe, we understand a body of Indians of the same or similar race, united in a community under one leadership or government and inhabiting a particular, though sometimes ill-defined territory. That's a good definition of a tribe. That's a very good definition of a tribe. And by that definition, every country in the old world qualifies as a tribe. Every single one. Every European country, every Asian country, they're all tribes, as according to the Supreme Court of the United States, which I think is interesting because one thing that we have is a great deal of intellectual colonization of the old world by the new world based on the Enlightenment criteria that is being applied to countries that were not propositional nations. They're ethnic nations. And I think that's something that is worth exploring at a later date, but bear it in mind, because I think it does speak to many of the problems that we're having at the moment. But anyway, the Montoya case in particular was about Indians who had stolen livestock, and in which the theory was that the people who lost their livestock put a liability on the tribe, as the tribe was responsible for the actions of its members. And so the issue in the Montoya case was whether the tribe members were actually still a part of the tribe when the act occurred, and the court found that they weren't. But whatever. It doesn't matter, we're just talking about the definition of the tribe. But interestingly there, notice how the standard is different for the tribe and the tribesmen to the Americans and the post-Enlightenment people. Whereas you wouldn't penalize a community or hold a community responsible for the actual individual acts of the members. Whereas the way the tribe works and the sort of relational bonds that bind the tribe together, they don't really recognize the individual as being something as separate from the tribe. So anyway, the authors complain that these conceptions, as in Western conceptions of race, leadership, community, and territory, were entirely alien to Mashpee culture. And this is another important point. Like, to be an atomized individual, to be something separate that can be considered from a kind of community, throughout history, this was a punishment. This was something that was used to hurt people. This was not something that was normally claimed. In fact, that would mean you were alone and insecure in the world, and that wasn't something desirable. And so it's no wonder that this would be entirely alien to Mashpee Indian culture. So they feel that there's a disjunction between the ethno-legal categories and the Mashpee's lived experience. Yes, this is also probably one of the original points of the, quote, lived experience as well. Not that there's not any value in the term lived experience either, but it's not, of course, an objective category. But objective categories are not the only important categories. And I think that maybe the Enlightenment West needs to start figuring that out for themselves. Because in a kind of objective way, everyone does have a subjective experience. Anyway, but this meant that the tribe's testimony and evidence never quite signified within the idiom established by the precedent, as in they were speaking the wrong language, and the colonists couldn't really understand what the Indians were saying, and the Indians didn't really understand what the Westerners were arguing. And so this gave rise to an irrational decision that the Mashpee were not a tribe in 1790. They were a tribe between 1834 and 1842, but again were not a tribe in 1869 and 1870. And the critical race theorists considered this decision to be irrational because the judge had instructed them that if they concluded that the Mashpee had ever relinquished tribal status, they could not regain it, and therefore the court dismissed the Mashpee's claim. And so the Mashpee obviously challenged this, saying, well, look, we've never voluntarily disbanded and have existed as a documented and recognized tribe for over 300 years, which is not a very long time, really. But the problem with the definitional categories used in order to make sense of the circumstances meant that the colonial administration of the 17th century had used racial signifiers, as in white, black, or Indian, to determine between the groups, and the Mashpee, of course, did not. And so within the Mashpee Indians themselves, there were white and black and Indian people, all who considered themselves to be a part of the Mashpee tribe. Because they define themselves by membership of given communities, as in it is the relationship of the members of the Mashpee tribe to one another that defines their membership in the community, not according to, quote, blood, as in not according to an abstract categorical, as in you're white, you're black, you're Indian, whatever it is. And it was the Indian identity, specifically Mashpee identity, that determined membership in the tribe or not. And so the authors consider this to be the Mashpee being penalized for maintaining their Aboriginal traditions because they did not conform to the prevailing racial definition of community and society. And so you can see it's the conflict between objective and subjective categories. You can't say someone maybe you could say someone objectively identifies as a member of the Mashpee, but you can never prove it. That requires for them to give their own testimony on the subject. But saying someone is white, black, or Indian, that is an objective category that can be recognized and measured by someone outside of that individual. The challenges then were asserted within the laws of the state of Massachusetts, in which white Christians had appropriated the grounds of the Mashpee, and the Mashpee had rescinded from this, appointed their own preacher rather than a white Christian preacher. They were Christians as well, by the way, who essentially absconded. And so in 1833, an Indian preacher called William Apes led the Mashpee to petition the governor, and the petition began with, quote, "We as a tribe will rule ourselves and have the right to do so, for all men are born free and equal, says the Constitution of this country." Again, you can see two direct conflicts in philosophy there. All men are born free and equal, we as a tribe, as in the tribe refused to individuate themselves in order to gain the Enlightenment concepts of all men, each man, that is, being born free and equal. And this was an assertion of the independence of the tribe from within the laws of the state against the organization and confiscation of their land by state fiat. Again, the Americans have a long and complicated relationship with the Indians. And so the heart of the dispute was the status of the Mashpee themselves, whether they were legally a people and entitled to legal protection. From the Mashpee perspective, the facts that defined the Indians as a tribe also invalidated the transactions divesting them of their lands. From the perspective of the property owners in the town of Mashpee, however, those same acts proved that the Mashpee no longer existed as a separate people. And so where do you go from here? There are, of course, detailed legal questions regarding the law. I'm not a lawyer, but then critical race theory did come out of US law. And so it's no wonder that they're focused particularly around it. The judge in this case was a Judge Skinner, who could not find an objective definition of what a tribe constituted, so he turned to the legal standard considered to be ethnocentric by the critical race theorists by using the precedent of Montoya versus the United States, and extracted the principles from it to judge the Mashpee's claim to tribal status. This abstraction to legal principles is a form of subtraction of the facts of the direct lived experience of the Mashpee, and in the critical race theorist view, and probably correctly in my opinion actually, failed to fully encapsulate the problem. This legal storytelling is, in the author's view, an exercise of power in deciding what precedents count and evades questions of power, perspective, and value. And so that's probably true. It's probably true that the Mashpee were actually dealt with unfairly here, because the English-speaking colonizers weren't able to properly understand, even though they were supposed to have protections for the Native Americans on their own tribal lands, and they should have had a degree of self-governing autonomy. Even though that was the case in their own law, their failure to really understand the ideas that are, and failure to properly categorize the ideas that the Mashpee hold compared to themselves and their Enlightenment perspective has caused this breach. And so you get nonsense judgments like the Mashpee are not a tribe, the Mashpee are a tribe, the Mashpee are not a tribe again. It's like, this is not true, and the Mashpee recognize this. And frankly, I think the colonial administration recognized that as well. And so another important aspect of the Mashpee as a tribe, and I think this goes for all tribes, and it does, as we covered in the definition of a tribe, actually, if I can get it up again, but not that I can find it now, but the point is the tribe has a recognized, though maybe ill-defined territorial boundary. And this makes the Mashpee's relationship to the land to be an integral part of what it is to be their tribe. And they literally say, quote, "The land is a constituent element of the tribe itself." And again, that's important if you come from an old world country that is not a propositional nation. Since the tribe's claims were translated by the defendant into a foreign language to the MASH-P, and the structure used to make decisions was that of English framing, this, quote, stripped the land claim of nuances that deeds could not replace. The deeds only reconstituted the tribe's basic claim but also temporalized it. Deeds set it apart from the evolving tradition of the Indians' relationship to their physical surroundings, and at once both elevated and debased their relationship to the land. Isn't that interesting? I think, honestly, with mass immigration in the West, in Europe, we get a very similar effect, because it is true, I think, that the native nations of Europe also have this kind of tribal relationship to their land. It's something I'll expand upon at a later date, probably on lotuses.com rather than on YouTube, but I do think there is truth to this, and if we're after truth, well, we probably shouldn't deny it when we find it. But anyway, in the case of the MASH-P, this couldn't be proven. They could not, therefore, be self-governed if they did not adopt the methods of the government that provided documentary proof. And so the court was asking for a kind of evidence, as in bureaucratic documentation. I mean, I don't know whether the MASH-P were literate or not, so it may have been that they weren't, which is totally plausible. And so demanding written evidence from an illiterate tribe seems a bit unfair, to be honest, doesn't it? Just seems like it's not, it's deliberately setting them up to fail. And so the MASH-P could not provide this documentary evidence, this bureaucratic documentation, so they didn't keep it. I don't know whether they were capable of it. And they also did not view it as legitimate, because they were a pre-Enlightenment civilization. A small one, admittedly, but they told themselves stories. Their experience of the world was as what Steve Hughes put to me in another podcast we did as a cosmic people. They have a different view of the world and their place in it. But the European perspective, or particularly the English perspective, did not recognize the MASH-P claims as legitimate either, because their culture was rooted in the oral traditions and not bureaucratic ones. And so they say, quote, the stories that the members of the MASH-P tribe told were stories that legal ears could not hear. And I think that's probably true. I think this is probably one of the main contentions, in fact, that the Enlightenment has this way of abstracting everything into a series of abstract and universal categories that are slowly disintegrating the indigenous cultures of the places around them and atomizing the people within them. And I think that if the rise in mental illness and suicide is anything to judge by, this possibly isn't the best way for human beings to live, and maybe we need to reconsider that. I'm not saying reject it entirely, which is incidentally the conclusion of this essay, but I do think that maybe there's a lesson here to be learned. Anyway, so these poor judgments, of course, arose from the lack of understanding between these two cultures, and we get the critical race theorists who essentially just lay out what I've already claimed here. First, in claiming blood as a measure of identity, the defense argued to the all-white jury that black intermarriage made the MASH-P's proper racial identification black instead of Indian, because of the one-drop rule, which is not something I hold to, obviously, and it's obviously wrong, because this just isn't how a tribal structure works. The tribal structure does not use abstract universals. It doesn't care about skin color. It cares about self-identification and membership with the tribe. And so that's just not right. The second one is the trial court instructed the jury that the tribe could terminate through social or cultural assimilation of English forms and English labels. Well, I mean, I imagine they could, but that probably would destroy the MASH-P as a tribe, because tribe membership is based on identification. And if they begin to identify in a different way, well, that's the end of the tribe. And so the MASH-P adaptation to the state of Massachusetts was considered to be the proof that the tribe had surrendered its identity. But the thing is, the MASH-P didn't have any other way of actually presenting their case. And so, again, it seems like they're caught in this catch-22 where you're damned if you do and you're damned if you don't, which is a bit unfair, again, isn't it? But anyway, so this has, of course, become the necessary state of affairs, and it ultimately had been forced upon them. The documentary evidence, was privileged over oral evidence, effectively debased the MASH-P's foundation of self-knowledge, their way of looking at and knowing themselves. And we get an interesting parallel in this, in the, I can't remember the name of it now, but the knowledge system of the Maori in New Zealand is very much the same. It connects the people to the land, to the traditions, to, into the past, the heritage of both knowledge of the environment, the social norms and traditions and customs of the tribe, and that is the thing that they pass down in this sort of Burkean continuum. It's based in magical thinking, but it does have practical properties, and ultimately it is their local culture, and it is right that we don't just take that away from them by force. Not that, a few hundred years ago, I think that the people of this time had this kind of knowledge. I mean, essentially what the English colonists were doing was practicing their own native culture in kind of the same way. But again, it's something I'll get into another time. But anyway, so they say that the relations must be translated into the form established by the rules to be comprehended by legal discourse, regardless of whether the self-constructed reality of the mashpee corresponds to the legal model. As in, the abstraction to legal reality ignored the content of the real reality that the mashpee were living through. And so the authors conclude that the problem with the mashpee lies in the construction of individual rights. And that's the very beating heart of the Enlightenment project that they are attacking now. So are we considering a substantial ethical order of traditions and laws of a given community, which is something collective, or are we proceeding atomistically from the bottom up, beginning at the individual? The claims made by the mashpee as a tribe challenge this individualistic order, but it also destroys the aboriginal claims the mashpee make. Quote, "The preservation of an alternative order is a direct challenge to the power and sovereignty of the country itself." And that's true, because if the mashpee can have this, then why can't anyone else have this? Why can't the black community have this? Why can't, anyone? Why can't the white community have this? Why would the United States not just break up into a patchwork of tribes? But of course, the critical race theorists are in favor of this. They say a real cultural pluralism in their view is one that should respect the cultural foundations for differently conceived notions of the good and provides a social space for such conceptions to take on a material form. They recognize that they are promoting a fundamentally anti-liberal view. But the thing is, they're not liberals anyway. They're a bunch of communists. Of course they're going to promote an anti-liberal view. Ironically, though, this is also an anti-communist view because this is not a materialistic view of the world. And so it's interesting how the critical race theorists are kind of leapfrogging everything in a way. So they understand that this anti-liberal view will, of course, limit the individual's capacity for self-determination. This questions whether it is even feasible to provide one. This is like the bleeding edge of Western philosophy at the moment. So I don't have an answer to this, and who knows where this goes from this point onwards. But I do think that conservatives should be paying close attention to this, because there is a deep underlying conservatism when it comes to the critical race theorists caring about the mashpee tribe. I mean, the mashpee tribe have been described in what is essentially Burkean conservative terms. So it's very, very interesting how they've arrived. And this is why this essay is such a strange and unique thing in the Bible of critical race theory that we're going through, which I didn't get for this video, but it's on my desk. But this is why this is such an unusual thing, because at bottom, we've almost sort of returned to sort of Marx's lament to the destruction of feudal bonds. And this is an undercurrent that's kind of always present in the back of their minds, I think. Anyway, they say any attempt to remake the argument for Aboriginal claims from the perspective of liberal theory is fundamentally misguided, as in it can't really be done in liberal theory. Liberal theory ends, or begins even, and ends with the liberation of the individual from anything that could prohibit their freedom. And if that's social custom, well, it's social custom that makes the tribe. And so they need to be liberated from the tribe itself, which is why you would need a social contract, incidentally. And I'm definitely souring on the idea of social contract theory, but that's for another time as well. Anyway, so they finally conclude with, quote, "It may be required to include a rejection of the Enlightenment project that lies at the heart of liberal democratic theory." As in, this is why, or one of the reasons why, they seek to just reject the structure, the governing structure, the moral and philosophical structure of the United States itself, because that is a propositional theory that comes from the Enlightenment, and that is one of the reasons that these sort of native conservative tribes are being eroded. There's a lot more to talk about here, but I'll do it another time. See you next time.